A very good afternoon to all my professional colleagues and our eminent speaker for this session. I welcome you all at this second webinar of the series on alternate dispute resolution ADR, which is recently announced by the ICSI, mainly to inculcate in-depth understanding of the legal framework and the practical aspects of ADR, including arbitration, mediation, and conciliation. I'm happy to share that the first webinar of series was a huge success with more than 15,000 participants on a weekend, which shows the interest of professionals fraternity in the subject matter. I'm hopeful that we continue to get similar amount of participation for this webinar as well, which I am pleased to host on behalf of the ICSI. Friends, while the first webinar of series was focused on arbitration, the today's webinar has been designed to focus on mediation and conciliation in order to give a complete picture of the ADR and related aspects. Before we delve into the heart of the matter, let us take a moment to appreciate the significance of mediation and conciliation in our contemporary world. Rapid globalization and an ever-evolving business environment have paved the way for complex disputes and challenges that demand an innovative, efficient, and cooperative approach to dispute resolution. In this context, the role of mediation and conciliation remain important, which offer a unique opportunity for parties involved in the dispute to come together in a non-adversarial setting and find mutual agreeable solutions. These ADR mechanisms allow to foster an environment of open communication, empathy, and collaboration, which are fundamental to resolving conflicts amicably. As company secretaries and professionals entrusted with the task of ensuring corporate compliance and ethical governance, it is incumbent upon us to embrace these alternative dispute resolution methods. By doing so, we not only uphold the principles of justice and fairness, but also contribute to the promotion of conducive business environment that facilitates sustainable growth and development. As part of a media report, recently the Union Cabinet cleared changes to the mediation bill, which was first introduced in Rajya Sabha in December 2021 and was sent to a parliamentary standing committee, which submitted its report in July 2022. The amendment bill makes pre-litigation voluntary, leaving the parties with the choice to participate in a pre-litigation mediation process instead of litigating. The change is in line with the suggestions of the standing committee, which had said that mediation must remain voluntary and they restrains parties from approaching courts or tribunals may amount to denial of access to justice. Now, some additional information which I wish to share. The context of the bill, the mediation bill, is the huge pileup of cases in the judicial system. It exceeds 45 million, with almost 90% pending in district and subordinate courts. Now, it is time to have the privilege of hearing our esteemed speaker for today's session, Mr. Krishna Grindi, who is well-known expert in the field of mediation and conciliation. I briefly read out his profile for the information and for the benefit of the members and those who are participating. Mr. Krishna Grandi is a designated senior advocate in India, practicing primarily before the Honorable Supreme Court of India, the Honorable High Courts, commercial courts, and various tribunals. As part of his dispute practice, he is engaged in several national and cross-border complex commercial disputes and is routinely approached for issuing legal opinions on international disputes involving multiple jurisdictions. Krishna Grindi has over 22 years of international experience working in legal, tech, and policy sectors, especially in the US and in India. With respect to commercial litigation, he has been instrumental in several precedent-setting matters in insolvency and bankruptcy court and advised on number of commercial transactions involving the application and interpretation of contract law and company law with respect to white-collar defense and economic crimes. He has advised and represented a number of high-profile clients across India on matters pertaining to Serious Fraud Investigation Office, Central Bureau of Investigation and Enforcement Directorate, prevention of corruption and anti-bribery and other economic crimes. Mr. Krishna Grindi received his BSc and MS in computer science from Cleveland State University, Juris Doctor from Cleveland Marshall College of Law at CSU, and an MBA from Cornell University. He is a dual qualified lawyer with a license to practice in both United States and in India. He is also uniquely qualified as United States patent attorney with a specialization in technology patents. Sir, I extend my warmest welcome to Mr. Krishna Grindi. I also request all the participants to actively engage in this webinar session and share relevant questions through chat box for expert views of our eminent speaker. Sir, over to you, sir.
Good afternoon, sir. Good afternoon, everybody who's participating today in this webinar on a Friday afternoon, taking out your valuable time. I really appreciate it. And I thank ICSI and the panel of members who invited me today to be here as part of this program to spread some awareness of the alternative dispute resolution mechanisms that we have available here in our country for us. I'm happy to be here. And the focus and goal of this presentation is to introduce the concepts of mediation, the concepts of conciliation, understand the statutory framework under which mediation and conciliation are organized within our laws in India. Talk about the mediation bill, which has created quite a bit of an excitement in the legal circles, in the company secretary circles, in all of the professional circles where corporate disputes are involved. And we will end the discussion with a way forward, looking forward into the future for this profession of company secretaries and how the company secretaries would be able to get themselves involved in the process of mediation, not only for the betterment of their clients' outcomes, but also as an additional career opportunity for all the company secretaries in our country. So that would be the flow of the presentation today. Having said that, I think we could get started with the presentation, sir, with the first slide. We will, like I have earlier indicated, we will understand the meaning of mediation, the different types of mediation that we have in our country, how mediation is currently recognized in the statutory framework in India. Then we will talk about conciliation and the statutory framework of conciliation within India. And there are just a few significant differences between mediation and conciliation when it comes to our statutory framework. We will touch upon that. Most importantly, we will then talk about the enforceability of such mediation and conciliation settlement agreements that come to play at the end of any mediation or conciliation proceeding. Thereafter, we will touch upon all of the salient features of Mediation Bill 2011 because the bill is quite large and complex. So we will not go through all of the provisions, but we will go through some of the salient features which I feel are necessary for a comprehensive understanding of the bill. And like I had indicated earlier, the most important takeaway, I think, at the end of the day for today's session would be not only to understand the concepts of mediation and conciliation, but also to understand how company secretaries figure in the whole larger model of mediation and conciliation in our country. And we will close this particular session with some questions and answers that will come both from the panel as well as the participants. That is the flow of the event today. So we can go to the next slide. So when we talk about mediation, you know, we have these official definitions, we have definitions given to us by the textbooks. But in our country, uniquely to our country, mediation has been part of our ethos for hundreds of years. In fact, the very first type of mediation that we have implemented as a country at the village level, at the taluk level, at the mandal level, are what we all know as panchayats, where the head of the panchayat committee sits down and mediates disputes between different parties that belong to a certain village or a certain mafsil. So mediation as a concept has been there in our country from a very, very long time. This is not something that has just started. But in terms of the official definition, I would say mediation is one of the three methods of alternative dispute resolution. The one method is what ICSI has covered in its first event, which is arbitration, which still remains the most popular form of alternative dispute resolution in our country and also all around the world. Mediation and conciliation happen to be the other two types of, the most popular two types of alternative dispute resolution after arbitration. And the idea here is the parties to the mediation not only mutually select the mediator, who is an impartial and an independent third party, who has nothing to do with the parties or the disputes itself, with the role of such mediator only to assist the parties in coming up with a mutually acceptable agreement. So we will go into this a little more and a little deeper in the slides to come. But this is what sets the role of a mediator completely apart from the role of an adjudicator, which is what we are used to in the traditional forms of litigation, for example, in our court system. So mediation, in essence, is a very methodical process. It is not an ad hoc process as much as everybody believes it to be so. It is a very methodical process. There are best practices in place. There are institutes who have put out different models of mediation, which happen to be in a very methodical way. And it is a participatory process. So here, the parties get to be involved at the root level from the beginning to the end of the mediation process. And both the parties as well as the mediator, mostly the mediator, will then use different type of negotiation strategies, different type of techniques. A trained mediator has probably over 24 different negotiation techniques that they will have in their kitty to help the parties come to the best possible decision given the set of circumstances and the disputes at hand. So like I said, the role of a mediator is just to be a facilitator. The role of a mediator is not to adjudge. The role of a mediator is not to comment on the substance of the issue. The role of the mediator is not to take sides with either party. Their role is to encourage dialogue between the parties and to only assist the parties in the role of a facilitator to come to an agreement to resolve the conflict. So when we talk about arbitrators, as you might have covered in the first session, arbitration is a private and an informal process, as opposed to an adjudication, which is a public and a formal process, which is what happens in the courtrooms. However, both the arbitrators and the adjudicators do adjudicate on issues. So they decide on the outcome of the issues. They are not facilitating in a participatory process. They're actually adjudicating on an adjudicatory process. So that is the large difference. And the other important aspect of mediation, which makes it very conducive, even in commercial disputes, is that the decision on whether or not to participate in mediation is an entirely voluntary process. And this we will also touch upon when we talk about the amendments to the Mediation Bill 2021, as to how it started off as a mandatory process and now post the amendments from the Joint Parliamentary Committee as well as the amendments approved by the Cabinet just 2 days ago. This has been made into a voluntary process. The next slide, please. So mediation in India is largely divided into three different categories. There is the first category, which has been incorporated in our laws, primarily the Code of Civil Procedure under Section 89, where the court, when it believes that there is a possibility of a settlement in a case under Section 89 of the CPC, can refer the matter to mediation. There are also other court-mandated mediation procedures in other acts such as the Commercial Courts Act, especially Section 12A, which also mandates that a mediation be at least attempted prior to instituting a suit before the respective commercial courts. So that is the first category of mediation that happens in India. The second category of mediation that happens in India is the mediation that is specified in the legislations itself. And we will also cover this in a little more detail shortly. But for example, the Companies Act 2013, which all of you are mostly familiar with, Section 442 allows that the parties can voluntarily resolve disputes that they might have brought either before the central government or the National Company Law Tribunal or the National Company Law Appellate Tribunal through a mediation discourse through mediators appointed by the central government. So there is that legislation specified mediation, which is the second category of mediation in India. Both of these types of mediations are connected one way or the other to our court systems. Now, the final category of mediation that we have in India is what is known as a private mediation. So this is a type of mediation where the law does not necessarily specify nor even mandate that there be a mediation between the parties, but it is the parties who choose voluntarily to resolve their disputes through this alternative dispute resolution mechanism rather than approach a court system to resolve their disputes. And through this process, they would appoint a mediator to mediate the dispute. So these are the three categories of mediation that we have in India. Next slide, please. Now, in terms of the recognition of mediation in our legislative framework, as you all know, we have the Mediation Bill 2011, which is yet to become law in our country. But much before that, mediation has been ingrained in our statutory frameworks. The most predominant mediation inclusion in our statutes, as I have touched upon earlier, is the Code of Civil Procedure. In Section 89, it says, where it appears to the court that there exists elements of a settlement, the court may formulate the terms of a possible settlement and refer that matter to either arbitration, conciliation, judicial settlement, which most of you know as Lok Adalats in our country, or mediation. This is the most extensive usage of mediation in our country, is through the Civil Procedure Code's Section 89's implementation. There are other laws where mediation has been referred to. For example, Industrial Disputes Act 1947, which I'm sure many of you are involved on a day-to-day basis as part of your discharging of your duties as company secretaries. The Industrial Disputes Act 1947, Section 4 specifically refers to the appointment of conciliation officers to mediate and settle the industrial disputes. So for those of you who are familiar with industrial disputes, when disputes arise between the promoters of a company as well as the workmen or the employees of the company, the first step that is taken is mediation. Whether that mediation is conducted through the conciliation officers as envisioned under the Act, or very regularly and routinely, such mediation is also conducted by the Deputy Commissioners of Labor to try and settle the disputes between the promoters of the factories or companies as well as the employees and workmen. So this is something that has already been in place. Now, one of the more recent legislations is the Commercial Courts Act of 2015. And the original incarnation of this particular act did not have a mediation clause. But through amendments that came out in 2018, specifically Section 12A, the Commercial Courts Act recognized the importance of mediation prior to adjudicating on commercial disputes and have mandated that prior to initiating a lawsuit under the Commercial Courts Act, the parties must first engage in mediation, and only if the mediation fails or is unsuccessful, providing such a confirmation to the court, then the parties can institute a suit. There is one exemption to this. In the event that any of the parties are seeking an urgent interim relief before the respective commercial court, then such a mandate of instituting mediation prior to instituting a lawsuit is done away with. Now, unfortunately, what happens is, in order to get around this mandatory provision of 12A, where mediation is mandated to be engaged by the parties are routinely attempting to file frivolous interim relief applications before the commercial court. So this is one issue that we have seen. No matter what the intent of the legislature is, the parties always try and find creative ways to get around the legislative intent. And this has been one of the ways in which parties have gotten around the 12A restriction, is by filing urgent interim reliefs before the commercial courts. Next slide, please. Now, coming to Companies Act, which is the home base for all of you here. Section 442 provides that the central government shall maintain a mediation and conciliation panel for mediating actions before the central government, like I talked about before, the NCLT or the NCLAT. So let's say there is a matter pending before the NCLT or the NCLAT, or there is a dispute pending inter se with the central government. The parties can request either the government or the NCLT or the NCLAT for that matter, depending on where the matter is pending, to initiate a mediation proceeding before the mediation and conciliation panel for that particular state, in order to try and amicably resolve the issue. Section 442 empowers the parties to do that. Section 442 also empowers the NCLT and NCLAT to suo motu refer any matter that is pending before them to the mediation and conciliation panel, with a mandate given to such a panel to dispose of any reference made to it within 3 months of such a reference. So that is deeply ingrained in our system, and it is very routinely used by parties who are before NCLT and NCLAT. The next example is the Consumer Protection Act. Section 74, 75, and 79 of Chapter 5 of the Act contained very detailed provisions related to the mediation of consumer disputes. And these sections also give out very detailed instructions on the establishment of consumer mediation cells. So similar to mediation and conciliation panels that are established under the Companies Act, the states are directed to establish consumer mediation cells either attached to the district commissions or state commissions. Now, unfortunately, not all of the states in our country have implemented this, but there are certain major states like Karnataka, Telangana, Maharashtra, and some other states who have implemented these consumer mediation cells in order for consumers to inter se settle their disputes through mediation prior to the Consumer Protection Act being taken umbrage under. Before the district and the state commissions take reference of the issue, consumers can settle their disputes through these consumer mediation cells. Next slide, please. Now, that is as far as the mediation statutory framework is concerned. Now, conciliation statutory framework is a lot more straightforward. Now, the Arbitration and Conciliation Act of 1996, Part 3, specifically deals with the end-to-end procedures of conciliation in our country. It sets out when conciliation can be initiated. It sets out the process of appointment of conciliators. It sets out the duties of conciliators vis-a-vis resolution of the disputes that are referred to them, the powers of the conciliators, the power of conciliators to make a settlement agreement, and also talks about the enforceability of such a settlement agreement that is drafted by the conciliator in conjunction with the parties. This statutory framework has been very clearly laid out in the Arbitration and Conciliation Act. And in fact, India is one of the only developed countries around the world where conciliation has been statutorily codified. In most of the other countries, it's either arbitration or mediation. In our country, more than 20 years ago, we have decided that conciliation as a form of an alternative dispute resolution should also be codified, should be given a statutory weightage, and parties should be allowed to undertake conciliation as an alternative to arbitration, mediation, or any other alternative dispute resolution. The other statutory framework that talks about conciliation is the MSME Act of 2006. Now, this is a very robust act which has a very robust provision for conciliation and arbitration. So, for example, in any company that issues invoices routinely, if that company is covered as an MSME and the invoice payment has not come through on an issued invoice, on the date of payment due on the invoice, or if there is no date of payment due on the invoice, within 45 days from the acceptance of goods or services provided by such an MSME, the company that has not received the payment can initiate conciliation proceedings before councils known as micro and small enterprises facilitation councils. This is a time-bound process. And if the conciliation fails, or if the parties are not amicable to closing out the issue with conciliation, then the case automatically moves to the arbitration stage, which is either controlled and governed by the MSME facilitation councils themselves, or the councils have the opportunity and the ability to refer the arbitration to an outside arbitration institute. Whether it is the councils or the arbitration institute, they are bound by the Arbitration and Conciliation Act and the rules they made thereunder in terms of how they conduct the arbitration proceedings under the MSME Act. And finally, the Real Estate Regulation and Development Act, also popularly known as the RERA Act, Section 32G. And again, just to be clear, this is not a mandatory requirement. It is only prescriptive that the central government may call for conciliation of disputes between the promoters and allottees through a recognized dispute resolution body. But a reference has been made to conciliation in the RERA Act as well. Next slide, please. Now, when it comes to differences between mediation and conciliation, there is a lot of confusion. In fact, there are Supreme Court judgments that went on so far as to say that mediation and conciliation must be used interchangeably, that there is not much of a difference between the two forms of alternative dispute resolution. However, the Supreme Court themselves, through their Mediation and Conciliation Project Committee, has put out a note talking about the major differences between the mediation and conciliation routes as ADR mechanisms in our country. The top three differences is what I have for you here. The function of a mediator is mainly facilitative. They will not, as I said earlier, adjudicate the matter for sure, nor will they actually play an active role in suggesting any routes that need to be taken by the parties to come to a conclusion. They will not suggest alternatives. Their role is 100% facilitative role, as opposed to conciliation, where the function of the conciliator is a little more active than the merely facilitative function that is taken up by the mediator. In fact, conciliators are also empowered to suggest possible solutions to the parties through their conciliation sessions. The second major difference is the consent of the parties is not mandatory for referring a case to mediation. So we have looked at Section 89 of the Civil Procedure Code, where the code says that if the court is satisfied, or if the court is of the opinion that a certain dispute can be referred to mediation, if the court is satisfied that a dispute such as the one that is before them is capable of being settled through mediation, then regardless of whether the parties have consented to it or not, the court can refer the matter to mediation. However, contradicting this view, under the Arbitration and Conciliation Act, if a dispute were to be referred to conciliation, the consent of both the parties is mandatory. So this is a very big, important difference between mediation and conciliation. Now, when it comes to implementation, which is where the third difference comes to play, the court that refers the mediation will apply Order 23, Rule 3 CPC to pass a decree in terms of this settlement agreement that has been arrived by the parties to the mediation. Whereas in conciliation, there is no such intervention that is required. In fact, the agreement that is arrived after the conciliation session is enforceable as if it were a decree of court, as per the Section 74 of the Arbitration and Conciliation Act. So these are the three major differences. The function of a mediator is purely facilitative. The function of a conciliator is facilitative, plus they have the additional luxury of suggesting solutions. The consent of the parties is not mandatory in mediation. It is mandatory in conciliation. And the referring court in mediation applies Order 23, Rule 3 CPC for passing a decree with respect to the terms of the agreement. And in conciliation, no such additional confirmation is required because the enforcement is done per Section 74 of the Arbitration Conciliation Act, as if it were a decree of the court. Next slide, please. So when we talk about mediation conciliation agreements, we need to talk about the concept of enforceability, because ultimately, no matter what alternative dispute mechanism the parties choose to engage with, if the outcome of such an alternative dispute mechanism is not enforceable, either privately or through our court systems, then there would be no reason for the parties to engage in an alternative dispute resolution. So let us look at what is the state of the mediation settlement agreements and their enforceability as it stands today. Because once the mediation bill is enacted into law, all of this will change. But as it stands today, what is the scope of the mediation settlement agreement? As we understand, a mediation settlement agreement is an agreement reached through mediation between the parties, and whatever is their understanding is reduced to writing. And such a writing is known as the mediation settlement agreement. It is basically a document that provides a certain obligations on part of each of the parties that they will have to abide by, because those are the terms and conditions that they themselves have agreed upon during the mediation sessions. This is a significant piece of writing, because this enables the parties to take control of their own risks. So the risk setting is done by the parties. The risk absorption is done by the parties. Future setting is done by the parties. And the parties reduce their understanding into writing. Next slide, please. Currently speaking, there is no statute governing mediation in general. We all know this. That is why Mediation Bill 2021 came into force. So strictly speaking, a settlement reached through mediation, especially when we talk about private mediation, is not legally enforceable unless and until we are talking about a mediation agreement which is later ratified by the court, like we have seen under Section 89 of the CPC. So essentially, it comes down to the willingness of the parties themselves, whether or not they are willing to enforce this so-called mediation settlement agreement. However, having said all of that, there is a caveat. If this agreement takes the nature of a contract, then this becomes an enforceable agreement. So that is what we will discuss on the next slide. So an agreement reached through private mediation has the same legal standing and ability to be enforced as a contract under the definition of an agreement enforceable by law as set out in the Contract Act, Section 2, subclause H. Therefore, if a private mediation settlement agreement meets the criteria of being a legally binding contract. And what are those criteria? All of you know this. There should be an offer, there should be an acceptance, there should be capacity of the parties, and the subject matter on which the settlement has been arrived should be a legal subject matter. There are some basic terms of when an agreement becomes enforceable by law under Section 2H. So as long as the settlement agreement, the mediation settlement agreement, conforms to these principles, then that particular agreement will be enforceable just as a contract under the Contract Act 1872. Next slide, please. Now, when it comes to conciliation settlement agreement, I think this is rather an easier thing to understand because the Act itself sets out the different permutations and combinations of what happens in a conciliation settlement agreement. So Section 73, when we look at it, it says when it appears to the conciliator that there exists elements of a settlement which may be acceptable to the parties, then he can formulate those terms of settlement and give it to the parties for observations. And after receiving their observations, they can reformulate such particular elements and make it into a written settlement agreement. And this particular written settlement agreement can be signed by the parties. And once it is signed, it shall be final and binding on the parties. So we are talking about the conciliation settlement agreement here and not the mediation settlement agreement, where the statute itself provides the different pieces and parts to this agreement. So we've looked at Section 73. Now, next slide, we will look at Section 74. Where Section 74 says, what is the status and the effect of such a conciliation settlement agreement? It says the settlement agreement shall have the same status and effect as if it is an arbitral award on agreed terms on the substance of the dispute rendered by an arbitral tribunal under Section 30. Now, what is an arbitral award on agreed terms? This may be something that may have been covered in the first session on arbitration. When parties go before an arbitral tribunal, there are two possible outcomes. The arbitral tribunal can either adjudicate the matter on substance and on the issues and issue an arbitral award at the closure of the arbitration proceedings, or the parties to the arbitration can come together to settle on the matter, at which point they can submit their agreed upon terms to the arbitrator and request the arbitrator to issue what is known as an arbitral award on agreed terms. So if we look at Section 30, settlement of the Arbitration and Conciliation Act, it goes like this. It is not incompatible with an arbitration agreement for an arbitral tribunal to encourage settlement of the disputes, and with the agreement of the parties, the arbitral tribunal may use mediation, conciliation, or other procedures at any time. If during the arbitral proceedings, the parties settle the dispute, the arbitral tribunal shall terminate the proceedings, and if requested by the parties, record such settlement in the form of an arbitral award on agreed terms. An arbitral award on agreed terms shall be made in accordance with Section 31, and an arbitral award on agreed terms shall have the same status and effect as any other arbitral award on the substance of the dispute. So essentially what happens is, once a conciliation settlement agreement is entered into by the parties, it gets the same effect as an arbitral award under the Arbitration and Conciliation Act, indirectly saying that this would be as good as an arbitral award in terms of its enforceability. Next slide, please. Now that we've talked about mediation and conciliation, the statutory framework that involves mediation and conciliation, and also the enforceability of awards that come out of the mediation and conciliation proceedings. Now it's time to move a little forward and talk about what is happening now. Now, we have only talked about domestic mediation. We've talked about domestic conciliation and disputes between parties in our country and not with parties outside of India. What happens when parties are from different jurisdictions and not necessarily just from India. We need to have laws in place to cover such multilateral, bilateral disputes that arise out of international commercial transactions. Keeping such an issue in mind, the Singapore Convention on Mediation, also known in short as the Singapore Convention, came together. It is a multilateral treaty which offers a uniform and efficient framework for the enforcement and invocation of international settlement agreements. When we talk about international settlement agreements, we're talking about necessarily more than one jurisdiction or country coming together. This convention provides the power to enforce mediation agreements in commercial disputes involving India and any other signatories to the convention. As of July 21st, 2023, there are 56 signatories, including our most frequently used trading partners who are China and America. And India themselves have become a signatory to this convention on 7th August 2019. So instead of enforcing the settlement agreement, we just talked about in India, in the current legal framework, we have to enforce the settlement agreement as a contract. Now that we are signatories to this Singapore Convention, and if this particular treaty is ratified by India, we would be able to enforce mediated settlement agreements by directly applying to the courts in our country to have that particular mediated settlement agreement be treated as a decree of the court. That is the big change that will happen once we ratify this treaty. Next slide, please. So Singapore Convention gives certain rights and obligations to each of the signatories. And one of those obligations is that each of the country then has to have its own version of a mediation act that largely encompasses the principles enumerated in the Singapore Convention. To that end, in our country, we have introduced the Mediation Bill 2021. As Sir had introduced at the beginning of this session, this particular bill was introduced in the Rajya Sabha on 20th December 21. On the same day, it was referred to the Joint Parliamentary Committee. And the Joint Parliamentary Committee gave a 2-volume report on the 13th of July, 2022. About a year later, and just about 2 days ago, the cabinet made its approval to those amendments. We are still not clear on whether the cabinet has approved all of the amendments, some of the amendments. Have they made any changes? The final text of the bill is not out yet. But at least 2 things we know for sure is that the maximum timeline for the dispute resolution that was recommended in the mediation bill to be 360 days has now been reduced to 180 days. And pre-litigation mediation, again, like Sir had suggested at the beginning of the session, which was earlier mandatory in the bill that was introduced in 2021, has now been made voluntary. Now, why has this been done? Article 21 of the Indian Constitution guarantees free and fair access to justice to all our citizens, and making mediation mandatory and stopping the access of these citizens to the court systems until mediation is completed was seen as a violation of Article 21 of our Constitution. And therefore, the Joint Parliamentary Committee has suggested that the pre-litigation mediation has to be voluntary and not a mandatory process. Accepting those amendments, the cabinet approved that this has to be a voluntary process. So those are the 2 things that we know for sure based on news reports that the cabinet has approved. As to the other amendments suggested by the Joint Parliamentary Committee, it is unclear, and we will only know once the final bill text is circulated by the government. In addition to the dispute resolution mechanism itself, what this bill will also do is establish something known as the Mediation Council of India, which would be the top regulatory body for all the mediators in our country. Next slide, please. I will go through some of the provisions of the mediation bill, which I think are very important for us to understand. But first, let us understand what is the purpose of the bill. The purpose of the bill is to encourage, facilitate, and advance institutional mediation as a means to resolving disputes. Because like I said earlier, we've had private mediations in the form of panchayats, private mediations in the form of family elders resolving disputes whenever family issues came about in our country for hundreds of years. But mediation has not been institutionalized to an extent where companies, corporate houses can utilize this particular mechanism to resolve disputes. The bill also suggests that we need to have mediation before court proceedings. We know that now that has been made voluntary. And it protects the plaintiff's rights to contact reputable adjudicatory forums or courts for a quick remedy. And in some circumstances, and this is something that is applicable whether it is arbitration or conciliation, and now I'm glad to see that it is happening in mediation as well, that immunity is granted to prevent revelation of the mediation proceedings. So this confidentiality is something that most of the corporate houses require, and that I'm happy to report is part of the mediation bill. A mediation settlement agreement, which is a result of the mediation process, is enforceable in court. And the bill envisages the registration of such a mediation settlement agreement with certain legal authorities that will be established under this act within 90 days of such a settlement agreement coming into force. Next slide. So I will go through certain key provisions of the bill, but largely the bill defines some legal terms and lays forth a uniform mediation process as opposed to the ad hoc mediation process that is being conducted in India right now. And one of the other major goals of the bill is there is going to be a separate budget that will be allocated to spread awareness of mediation in our country as a process that is less time consuming and a more affordable way to settle conflicts, not only in the commercial disputes, but also in non-commercial disputes. Next slide, please. So we will talk about the specific provisions, but on an overarching level, the bill outlines the duties and responsibilities of the mediators, which is obviously very important. We need to understand how they're appointed, who appoints them, and once appointed, what are their duties and responsibilities. It stipulates that all settlements or agreements reached through mediation shall be legally binding, and it would have the same effect as if they had been approved by a judge. In a sense, what we're talking about is a court decree. It also specifies the procedures to be followed in such a process and grants the courts and tribunals the authority to send cases to mediation, which is what we have right now also under CPC, but this would formalize it as a statutory provision for all the courts and tribunals in our country. The bill also gives the parties the option to withdraw from mediation procedures. The bill gives an option to ask for different mediators if they're not happy with the current mediator. It includes provision for online mediation, which is the next wave of mediation in our country. It describes the idea of pre-litigation mediation, now which has been made voluntary. It encourages institutional mediation. It also sets out what are the different types of disputes that are eligible for mediation and that are not eligible for mediation. Next slide, please. Now, as far as the timeline is concerned, like I had suggested earlier, it was a 360-day timeline, which was basically 180 days plus an extension of 180 days. What we come to understand now is this has now been reduced to 180 days period. There are no extensions available. And we are unsure if the earlier version of the bill, which mandated that there have to be at least 2 sessions by both the sides before which they can go to the court and inform that the mediation has failed. We are unsure whether that particular 2-session requirement has been kept or if it has been done away with by the cabinet. As far as the Mediation Council of India is concerned, we understand that there would be a chairperson, 2 full-time members, 3 ex officio members, and a part-time member. Next slide, please. Now, when it comes to the specific provisions of the bill basically has 65 clauses and 10 schedules. Now we'll go through some important and relevant clauses in the bill. Clause 2 is the applicability clause, which says this mediation is in India or an international mediation. Remember, we talked about the Singapore Convention and how the signatories to the Singapore Convention have to include for international mediation within their own country statutes. So this is being done under clause 2. it says that in non-commercial disputes where the government is a party, that mediation cannot happen unless the nature of disputes that can be referred to mediation have been notified by the central government. Clause 3F defines what is international mediation, which as I've explained, is nothing but where one party is not Indian. Clause 5 talks about a mediation agreement. Now, we all know arbitration agreements. It's a well-settled proposition of law. Arbitration agreement could either be a standalone agreement or it could be a clause in a contract where the parties agree to arbitrate in the event of a dispute. On the same lines, clause 5 talks about the mediation agreement, which again either could be a clause in a contract or it could be an independent agreement in and of itself. Then clause 6 talks about pre-litigation mediation, that whether any mediation agreement exists or not, civil and commercial nature suits in any court shall first be resolved by pre-litigation mediation. Now, this is what we have come to understand has changed, and the word shall might have been replaced with may. We are yet to see the final text of the bill. Clause 7, disputes or matters not fit for mediation. As I explained earlier, there is actually an indicative list under the first schedule where the bill specifically lays out those kinds of disputes or matters that cannot be mediated. Next slide, please. Clause 8 talks about the interim relief by either a court or tribunal. So what it says is either before the commencement of the mediation proceedings or during the mediation proceedings, a party can approach a court or a tribunal. Remember, either a court or a tribunal can refer the parties to mediation. So the parties are now free to approach the court or a tribunal to seek any urgent relief, either before the commencement or during the mediation proceedings. Clause 10 talks about mediator. It says that the mediator could be of any nationality. And if the parties don't agree on a mutually appointed mediator, just like what it happens in the arbitration context, they can go to this entity known as a mediation service provider, which would be, for example, an institutional mediation center for appointment. And such a mediator should definitely disclose if they have any conflicts, at which point the parties can choose to waive. Then clause 15 says to undertake mediation, it shall take place within the territorial jurisdiction of the court or tribunal of competent jurisdiction, unless the parties agree to conduct mediation outside of the said territorial jurisdiction, or by choosing to do online mediation. Now, this is also something that I will touch upon shortly, which I think is an unnecessary restriction on the parties. Now, clause 17 talks about the conduct of mediation. It says the mediator shall assist the parties in an independent, neutral, and impartial manner, and that the mediator shall not be bound by the CPC or the Indian Evidence Act. And the mediation can be constructed by a mediator as per the choice of the parties or by the courts, or if he is empaneled by an authorized institution or by a service provider. Clause 21 talks about timelines. We've just covered that point, that now it is 180 days. Clause 22 talks about the ultimate outcome of the mediation, which is the mediated settlement agreement. It says that this mediated settlement agreement has to be in writing. It cannot be void under the Indian Contract Act. This also we have touched upon earlier. The Indian Contract Act specifies the terms and conditions under which an agreement can be considered a contract. One of it, for example, is that the parties cannot have any incapacity, either mentally or physically. Another one is where the parties cannot agree to enter into a contract for doing something illegal, for example. So the same restrictions will apply even to the mediated settlement agreement. And in the event the party is submitted to mediation and mediation fails, now the mediator is mandatorily required to submit what is known as a failure report, where the mediator must enumerate the reasons why such a mediation has failed, and that needs to be made off record to either the court or the tribunal that has referred that mediation. And like I suggested earlier, just like arbitration, mediation is a private process, and clause 23 ensures that none of the proceedings, the contents within the proceedings, or any of the negotiations between the parties shall be disclosed outside of the context of the mediation proceedings, and such confidentiality is protected now as a statutory protection under clause 23. Next slide, please. Clause 28 talks about enforcement of the mediated settlement agreement, that the MSA is final and binding, and it is enforceable, like I said earlier, as if it is a judgment or a decree passed by the court, exactly like a civil court judgment or a decree. Clause 29 then talks about the various ways in which one can challenge the mediated settlement agreement. Now, if you think about it from a commonsensical perspective, this is no different from a Lok Adalat award. A Lok Adalat award happens when parties are referred to the Lok Adalat by a court of competent jurisdiction, when the parties approach the court and say, we either have arrived at a settlement or we are in the process of settling the matter. Please refer us to Lok Adalat so we can have Lok Adalat record our settlement and issue an award. Because it is voluntary and because it is done on the insistence of the parties, after the Lok Adalat award is passed, our law is very strict that it cannot be tampered with. The only way you can challenge a Lok Adalat award is to go under Article 226 of the Indian Constitution and file a writ petition before the concerned High Court on very limited grounds, such as fraud. The same idea is replicated even as part of this bill. Under clause 29, the challenge to an MSA can only be on grounds of fraud, corruption, impersonation, or where mediation is conducted in a dispute. Remember, Schedule 1 talks about the different areas, subject matters that are not fit for mediation. So if one of those subject matters is what is mediated, then those could be the grounds for challenging the MSA within 90 days. Clause 32 talks about online mediation and gives it a statutory blessing, if you will, to online mediation. Clauses 33 and 40 talk about the Mediation Council of India. It talks about the establishment of Mediation Council of India and also the objects of the Mediation Council of India, which is to promote mediation. Remember, one of the things that the mediation bill I suggested earlier is attempting to do is to promote mediation as an effective, cost-effective, and time-effective alternative dispute mechanism in our country, and to spread awareness of the same all through our country. So the Mediation Council of India promotes mediation, develops India as a center for domestic and international mediation, and also makes regulations. This is the most important part of the Mediation Council's job. It makes regulations for the registration of mediators and also grades mediators and mediation service providers. And it sets out specific criteria for the recognition of such mediation institutes and mediation service providers. Clause 44, and this is something very unique to India, and this sort of legalizes the panchayat example that I was giving earlier, where there is community mediation. It legalizes the idea of family mediation, for example, that has been happening for centuries in our country. And clause 44 talks about community mediation, and it says, with prior mutual consent of the parties for resolution of disputes which are likely to affect peace, harmony, and tranquility amongst the residents or families of any area or locality, and it powers the concerned authority or the district magistrate or the SDM to constitute a panel of 3 mediators for conducting community mediation. So this is a different take on the family/panchayat mediation, which we are already used to, but now it is being given a legal effect. Clause 56 talks about how the provisions of this act have an overriding effect of mediation that is mentioned, or mediation or conciliation that is mentioned in any other laws. Clauses 58 to 65 are provisions of consequential amendments. Amendments to the Indian Contract Act, Arbitration and Conciliation Act, the Code of Civil Procedure, for example. How once this bill comes into force, all of those particular acts will be amended, and a lot of them will be subsumed by the provisions of this bill. For example, in the Arbitration and Conciliation Act, the term conciliation is suggested to be subsumed by the term mediation as proposed by this bill. Next slide, please. Now, when it comes to the Joint Parliamentary Committee recommendations, after this bill was introduced, and we've just gone through certain important provisions of the bill, after this bill was introduced, the Joint Parliamentary Committee made some very important observations. It said, why are you excluding the government from mediation for non-commercial disputes? Because as you all know, as working professionals in our industry, who is the biggest litigant in the Indian court system? Sir has indicated 4 crore pending cases in the lower judiciary. Justice Rao, the Andhra Pradesh High Court, famously commented about 13 years ago that at that time, whatever the pendency of cases were, it would take more than 350 years or 380 years if all the judges worked to resolve those particular disputes through our adjudicatory system. He commented that it would take more than 350 years to just adjudicate the existing disputes in our court system. We've been told more than 4 crore cases are pending. Now, the question that needs to be asked is who files the most cases in our country? And it is the government. It's an undisputed fact that the government is the biggest litigant in our judiciary. So rightfully so, the Joint Parliamentary Committee asked a very pertinent question through their recommendations. And they said, why are you excluding the government from mediation, especially for non-commercial disputes? And the second recommendation that they've made, which I'm glad has been accepted, is do not make pre-litigation mandatory, because mandatory pre-litigation mediation may have the opposite effect, because the parties could use it as a delay tool. So it said, please make it optional. And if you want to make it mandatory, introduce it in phases, where maybe it could start off with some civil disputes and slowly make its way to commercial disputes. But from what we understand now, the whole mandatory nature of that clause has been taken away. And now it has become a voluntary tool, which is good. Because as I have given an example before, anytime you shove down an option down the parties' throats, which they are not comfortable, and you make it mandatory, the parties will always come up with creative ideas to get around that issue. We have seen this with respect to the implementation of 12A in the Commercial Courts Act. Because there is a proviso, there is an exception in that particular clause that says this pre-litigation mediation, which is mandatory, will not apply if one of the parties or both the parties are seeking some urgent interim reliefs. Now, what has happened is everybody seeks interim reliefs now, and they get around the pre-litigation mediation clause, which was mandatory. So I'm glad that this has now become voluntary. Again, the time limit has been reduced to our understanding by the cabinet to 180. The recommendation was to make it 150, 90 days plus a 60-day extension. The other recommendation that was made, we've just touched upon this earlier in the last slide. Online mediation has been given a legal blessing under the bill. So the JPC's view was don't just relegate it to a recognition, because this is the wave of the future. This is the emerging concept. Post-COVID, the entire judiciary went online within a matter of a month. Now parties are used to settling disputes, having conferences through an online medium. A lot of tribunals in our country still make it available to the litigants as well as the lawyers to appear themselves through a virtual medium. So online dispute resolution is the wave of the future. We have to adopt it. So the JPC said that instead of dedicating just one clause and accepting ODR as a valid dispute resolution mechanism, please incorporate detailed provisions, give the modalities, let people know how ODR can be conducted. There are so many ODR providers now, even before the bill has been introduced. Give them guidelines on how to operate, give them rules. So that was the recommendation. And they also talked about differentiating between mediators and community mediators. Because as we all know, community mediators are not necessarily trained. And they also made a suggestion that do not make it explicit that the community mediation settlement agreements are not enforceable. Why not? Because community mediators, even though they're not trained, have been conducting this job for centuries. Now we're giving it legal sanctity, great. but also give legal sanctity to the outcome of such community mediation was one of the recommendations. Next slide, please. So some of the issues that I thought I should bring you. The bill says the interim relief by courts. We looked at the section that said that even either during or before the institution of mediation proceedings, the parties can approach the courts or tribunals for urgent interim relief. Now, who defines what is urgent interim relief? It's better to get rid of these vague, non-specific terms from the bill. And if the bill purports to give clarity on this interim relief, let them introduce a schedule whereby they give different categories of interim reliefs that are allowed under the bill. Now, when it comes to foreign mediators, they say the foreign mediators are required to have qualifications, experience, and accreditation as may be specified presumably by the central government. Now, this to me goes against party autonomy. Let the parties choose. If there is a dispute that relates to patenting of a technology, for example, and if the central government, in its wisdom, decides that the qualification, experience, and accreditation has to be a certain way for a construction dispute, it may be okay. But for a patent dispute, it may not be okay. Especially because this is a party-initiated process, our suggestion should be that there has to be party autonomy. Party autonomy, this I touched upon when we talked about the place of mediation, has to be completely on the parties. Why restrict this to just the jurisdiction where the dispute can be tried in courts? Then the end result is we are again tying the mediation also to the court system. Mediation is supposed to break free from the shackles of the court system. It is supposed to create a fresh, new avenue for the parties to settle disputes. The parties want to settle disputes in Jammu and Kashmir, where the jurisdictional court happens to be maybe in Hyderabad or Delhi. Let them do it. The whole idea is to create a conducive environment, either physically or online, where parties can feel comfortable talking about the dispute, understanding the various issues that may come about in the future, and arriving at an amicable settlement. So there is no need to restrict the parties to mediate only in the jurisdiction where the courts have jurisdiction over the dispute. Another party autonomy, and the reason why I'm harping on party autonomy is that is the entire premise of mediation. The foundation of mediation is party autonomy. Now, the current bill says the mediators cannot act as arbitrators later. Why? Why put arbitrary restrictions on the role of a mediator and an arbitrator? If the parties so choose, if the parties are content with the conduct of the mediator and would like the mediator to also act as an arbitrator in the event mediation fails, let the party choose. And for court annexed mediation, the bill proposes the rules to be set by the High Court or the Supreme Court. The bill also says the provisions don't apply to Lok Adalat proceedings. This creates unnecessary confusion and limits the bill to private mediations only. So this, in my view, is unnecessary. Also, according to the schedule, all criminal cases are excluded from mediation. Well, I understand. I have defended criminal cases. I have assisted prosecution in criminal cases. I understand for serious offenses, absolutely. Let us not have any mediation, a chance at mediation. But let us talk about non-serious offenses in the perspective of IPC. Let's talk about quasi-criminal cases, for example, check bounce cases. Or when we are talking about 498A cases, which are family-oriented mostly, as most of you know. They have a flavor of a criminal case, but are they not amenable, I should say, to be settled through mediation? I would think so. Not in all cases, but let us not put a blanket restriction that all criminal cases will not be amenable to mediation. I think in certain limited circumstances, especially when it comes to check bounce cases and certain family-oriented criminal cases, I think mediation may still be a viable alternative than going to courts. Next slide, please. Now, when it comes to opportunities, because that is one of the things that I said I will touch upon at the end of this presentation. We're almost at the end of this presentation now. What are the opportunities for company secretaries in the field of mediation? The one opportunity that we currently have, despite whether or not the mediation bill comes into force, is the Companies Act. Section 442 provides, like I said, for mediation and conciliation as a viable option to dispute resolution. And the Companies Mediation Conciliation Rules 2016 have also been notified by the central government. Now, the central government, what it has done, it has defined a framework for the appointment of a panel of mediators and conciliators. And their job will be to convey each party's perspective in a dispute, identify problems, lessen misunderstanding, make the priorities of the parties clear, and facilitate a voluntary resolution. Like I touched upon earlier, whether it is a dispute with the central government, whether it is a dispute pending before the NCLT or the NCLAT, the parties are free to approach that particular forum and request that their dispute be referred to the mediation. And in such a reference, the requirement of a mediator comes into play. And who can be appointed as a mediator by the central government is explained in the next slide. According to the Companies Mediation Conciliation Rules, please go to the next slide. Here is the statutory framework. So Rule 4 of the Companies Mediation Conciliation Rules set out who can be eligible to be empaneled as a mediator. As you all know, these empanelment notifications come in periodically by each of the ROCs. And one of the qualifications here, I've highlighted that in red. It says is or has been a professional for at least 15 years of continuous practice as a chartered accountant, cost accountant, or company secretary. So if a company secretary has 15 years of experience, they can choose to apply to be an empaneled mediator with the central government under the Rule 4 of the Company Mediation and Conciliation Rules. Next slide. But until then, if somebody doesn't have 15 years of experience, or if they do not want to empanel themselves with the central government, my suggestion would be to start participating in the alternative dispute resolution process with your companies right from now. The ultimate goal could be to act as an arbitrator or to act as a mediator. Until you get there, where you could start is you could start by representing the parties at the mediation sessions or the arbitration sessions, because there is no requirement that a party take only a lawyer to a mediation session. It could be literally anybody. And who better than a company secretary who understands the intricacies of what is happening with their company end to end? Who better than somebody who not only understands the law, because necessarily all company secretaries are trained in the law, but also one who understands business. A lot of company secretaries that I know have MBA degrees, have accounting degrees, are very well versed with the functionings of a company. They understand balance sheets, they understand financial statements, they understand the law. Thereby, if there is a dispute, they understand how to resolve the dispute, sometimes even better than the lawyers representing such companies. So take advantage of this whole idea that at the mediation sessions, there is no legal requirement for a lawyer to be present. So company secretaries can start by volunteering to represent the parties as the party representatives at the mediation and arbitration sessions. Like I said earlier, they can also register with the central government to act as mediators on the council panels. But the most exciting opportunity, I think, is coming, which is the mediation bill. Once the mediation bill is enacted, the floodgates will open for literally thousands of mediators who will be required to help parties all across the country. This will not be limited to metros. This will go through all of the country. Like how IBC or the Companies Act have been revolutionary in creating opportunities for lawyers, company secretaries, and chartered accountants. I believe that once the mediation bill is enacted into law, it will create thousands of opportunities for company secretaries to act as mediators. But in order for you to take advantage of the opportunity, because the mediation bill, in my view, is coming. The act is coming. Sorry. It is proposed to be introduced in the next session of the parliament. Joint parliamentary committee recommendations have been made. Cabinet approval has been done. The only step that is remaining is to be introduced in the parliament, in the both houses, and to pass it into law. Now, unlike a lot of other laws that may be controversial, mediation bill has very limited resistance from any side of the aisle in our parliament. So more than likely, my prediction here is that the mediation bill will become law in the next few months. So what do we do to get prepared for the onslaught of opportunities that will come our way? My suggestion is obviously attend seminars such as this, which will give you a bird's eye view, because in 1 hour's time, we cannot cover every single detail of every single aspect of mediation or conciliation, but I think we have covered plenty to give you a bird's eye view of what mediation and conciliation is. Attend more of these seminars, but more importantly, kindly enroll in a mediator training session. There are a number of online and offline mediator training programs available in India. Some are accredited by international bodies like the International Mediation Institute. Some are not accredited. It doesn't matter. For the time being, the idea is to understand how to serve as a mediator. Enroll in any course that gives you the basics of how to be a mediator. Start by representing your parties at mediation sessions. And once you build enough confidence that you will be an effective mediator, then you could enroll in upskilling courses recognized and accredited by international bodies. You can spend the time and money there prior to plunging full time into acting as a mediator. And one thing I must make clear, the potential to earn a more than decent living, in fact, a very good living, is very high, even if you choose mediation as a full-time opportunity once the mediation bill becomes law. This is not charity. This is not something that people do not pay for. In fact, there are instances internationally when mediators are paid on par or above what an arbitrator is paid. So this is a great opportunity. And with that, I would like to close my presentation. I think I have gone over my time limit. I apologize. But I think we can open the session for any questions and answers. Thank you.
Sir, very wonderful presentation on basics of mediation and conciliation. I have received some questions from the participants. We'll try to answer as many questions as possible. Basically, I have one question, sir. How does this mediation happens, and what are the steps or stages that are involved in the mediation?
Sir, that is an excellent question. I think for those of you who have not been part of mediation sessions, I think this actually would be a very important question, because mediation and what happens inside the closed room is like an enigma. A lot of people don't understand how it is done. So there are various stages and steps, sir, that happen in mediation. I will be happy to go through each of them. So once the mediation session starts, so we have two parties, multiple parties come to a mediator. The mediator and the parties sit together, generally in an institute or some sort of a conference room facility. And the session starts with the mediator's opening statement. And the mediator's opening statement basically sets the tone for the entire session and says that here is who I am. I will be the one conducting the mediation. It will attempt to establish the relationship between the parties. And it will attempt to establish a relationship with the parties. So both between the parties and with the parties, that is how the mediators, it's called the mediator's opening statement. That is the first step. Then thereafter, the parties themselves also make opening statements. So this is how a structured mediation is done. So just as an aside, sir, I have been trained as an international mediator by the Singapore International Mediation Center, SIMC. So one of, I think, less than 100 people in our country who have been trained by them, fortunately. And this is the training that we have received. This is the process that SIMC follows. There are other mediation institutes that may have a slightly different take on the various stages. So I'm telling you what I practice. So once the mediator statement is completed, then we have what is known as the party statements. And it allows the parties to summarize what the issues are, why they are here in the first place, and what they choose, what they seek to achieve at the end of the mediation session. Then what happens is we have something known as the agenda setting. That is where the mediator comes into play. Generally, it happens with a blank whiteboard where the mediator says, I will allow you to lead this particular session. Why don't we frame all of the issues that you have brought about in the opening statements that you've made, but let us do that in a neutral language, which is a very important step, sir, because what happens is there is a lot of animosity. There is a lot of ill will, bad blood between parties generally, because that is why disputes occur. So when the parties are making their opening statements, despite clear instructions by the mediator, sometimes very charged language is used, negative language is used to describe the issues. So what the mediator does is they don't do anything legal. They don't create these questions on the agenda from a legal perspective. It is run by the parties and it is encouraged by the mediator to frame the issues in a neutral language and not in a negative language. Once that happens, we go through a stage known as exploration of issues. So basically that is the stage where the issues that have been set in step 3. So step 1 was the mediator's opening statement. Step 2 is the party's opening statements. Step 3 is what I have called as the agenda setting, where we outline the issues in neutral language. In step 4, we take those items that are in the agenda and we explore them deeper. And that stage is known as the exploration of issues. So that stage takes the most time, because that is where we go through on a much deeper level each of the issues that have been set as part of step 3. Then what happens is, after the exploration of issues happens, the next step, which is step number 5, is what is known as the private sessions. So this is where the mediator takes each of the parties into private sessions. Here, confidentiality is important. We tell them upfront that anything that they say there is confidential and shall not be shared with others outside. And most importantly, this session is utilized to extract any confidential information that the parties want to share that may have an impact eventually on the final outcome of the settlement. So the way it is done is we go to private sessions. Each private session, we have a one-on-one discussion with the party, extract any confidential information. When we go to the other private session, there is no disclosure of such confidential information. We take on new information from them, understanding that it's confidential in nature, and we put those pieces together. Then the next stage is the final stage, which is basically the closing. So the closing stage, sir, is where we call the parties back into the neutral room and we say, basis what we have understood, here are the issues, here are the things that need to be discussed deeper, here are the things that we have already agreed upon, right? Because during the private sessions, also part of what happens is the mediator asks the parties whether they're agreeable and amenable, because this they may not want to say in front of the other party for various reasons, including, there are egos that get built up in these situations. So we get a list of all the things that are absolutely possible to be settled upon from both the parties in the private sessions, and we present them to each other during the closing session. And that is where the session closes, along with any unironed out areas that need to be ironed out in finality. So these are the various steps that happen in mediation.
Thank you, sir. Can I go to the next question? One participant has raised a pertinent question. What he's asking for, explain the requirement for documentary evidence in mediation and conciliation.
Sir, documentary evidence, that is an excellent question. So as I have covered earlier also, mediation sessions are not under the purview, need not be. Well, if the mediator and the parties agree to it, then that is a different issue. Need not be under the purview of the Indian Evidence Act. Therefore, we are not bound by the restrictions put forth by the Indian Evidence Act, either primary evidence or secondary evidence or electronic evidence of whatever nature. Whatever is the information the parties choose to share with the mediator in whatever form and format is accepted as the truth and is not challenged per se by the mediator himself or herself. When that particular documentation is presented to the other side with the permission of the party, if the other side raises any objections, then we let the parties talk to each other and decide the veracity of the information that is being submitted. But per se, there is no restriction on the type of documentation that can be submitted during a mediation session. It is whatever helps facilitate the progress of the mediation session.
Thank you, sir. Next question. How successful is mediation in employment contracts, and any suggestion on a good mediation clause in employment contracts?
Sir, clause-wise, there is a lot of material available online. Mediation, basically, when I talk about mediation, we can talk about the med-arb type of clauses, or we can talk about the arb, med-arb type clauses. And I'll tell you what the difference is. Basically, if we talk about arb, med-arb clauses, what we are saying is, you can start off with arbitration. And during the course of arbitration, the parties will have an opportunity to mediate that particular issue. And if the mediation is successful, the process stops there. The mediation is not successful, they can return to the arbitration. So this clause is known as the arb, med-arb clause, which has now become a very go-to clause in most of the contractual drafting. That is something that they can consider. The other option, obviously, is the standard med-arb clause, which I'm sure most of us are familiar with, where it says if there is a dispute, it must first be resolved through mediation. And only if mediation fails, then arbitration shall be taken up. So that is the answer to the clause question. Now, when it comes to employment agreements, we have seen great success with mediation. Sir, because what typically happens in employment contract violations, there are very few sets of things that happen in employment contract violations. One is the employee might have left prior to the notice period. Another is the employee might have taken some confidential data with them. Another is where the employee might have taken company property with them. Or from the company's side, the grievance could be that the employee has not been paid accurately or on time, or bonuses have not been paid. These are the several bad categories or buckets under which employment disputes generally arise. Mostly, I mean, obviously there are outliers and more deeper issues. All of these issues I have seen successfully concluded with mediation, because ultimately it becomes an issue of egos. It becomes an issue of acceptance. Sometimes for the employees, it is simply an issue of appreciation. You would be surprised how many times disputes have been resolved with the employer simply saying, "You are doing an amazing job, thank you." This might sound very simplistic, but that is all they need. And a lot of times issues are resolved starting that as the foundation. So answer to the question, yes, employment agreements and employment disputes form a very good opportunity to use mediation for settlement of disputes.
Sir, I'm posing the next question. In your view, what are the main barriers to widespread adoption of mediation and conciliation in various industries? And how can we address these challenges?
Sir, I think the current barriers that we have are basically three. We are lacking a specialized legislation. There is no codification of mediation. That is the current barrier. I'm not talking about post-mediation bill. That is the biggest barrier. Because if we don't have a codified way of looking at a dispute resolution mechanism, like we have in arbitration or conciliation, it will be very difficult for us to inspire the confidence in the parties, especially when we are talking about commercial matters, where the quantum of disputes are quite high, where the failure can result in unintended consequences. If there is no codification of this particular dispute resolution mechanism, it will be very hard to inspire commercial entities to take up mediation. That has been the biggest barrier in my view. The second barrier, in my view, until now, is the lack of enforcement mechanism. So, sir, if you understand the differences between conciliation and arbitration awards and what happens in the context of mediation, is the conciliation and arbitration awards are given the flavor of a decree from a court. Once the award achieves the flavor of a decree from a court, what else is left? All that is left is to execute that particular award. But now contrast it with mediation. At best, what we said, we've covered it in 2 different slides today. At best, what we said was, if all of the requirements of the Indian Contract Act, ICA, are met, then this particular mediation settlement agreement achieves the flavor of a contract, and there is a breaking of the contract, a violation of the contract, we have to institute a suit for a breach of contract, which then has to be adjudicated like any other adjudicatory issue before a court. So now there is an additional step that is added prior to the enforcement of such an agreement. So that has been, in my view, a second large barrier to widespread adoption of mediation. And the third barrier, in my view, is the lack of institutionalization. We don't have institutes. Now we are coming up with institutes. We have the International Arbitration and Mediation Center in Hyderabad, which has been making waves in the arbitration and mediation circles in our country. We have other mediation and arbitration centers now in India. So we are slowly bringing this concept of institutionalization to mediation now. Until now, that was not there. So lack of institutionalization, where parties can go, understand that there are institutional rules and procedures to be followed in adopting mediation, is one issue. Lack of enforcement mechanism of the awards or the agreements, I should say, is another issue. And a lack of specialized legislation or codification, if you will, has been the biggest barrier.
So next question, interesting one. One participant says many Indian MNCs insist to mention the Singapore as arbitration in the agreement due to quick award or decision, which proves to be very expensive. So please guide which arbitration center in India we can put in the agreement and very effective.
Yes, no, that is an excellent question. This has been an issue that has been brought up by many professionals and industry experts. Now, the arbitration or mediation, when it happens outside of India, is a very expensive affair. There is absolutely no doubt about it. So with that expense, this has become the domain of only very wealthy parties, very wealthy companies, which is unfortunate. Especially we talked about Article 21, access to justice. And everything that you said just now seems to be opposite access to justice. If we are limiting access to good institutions only to those parties that can afford to pay, then there is something inherently wrong. Having said that, the finest institutions for mediation and arbitration are in Singapore. The finest, one of the finest institutions in the world are in Singapore. There is no doubt about it. But what do we have here? We have institutes here. Like I said, I am from the city of Hyderabad in India. We have an amazing institution here known as the IAMC. the International Mediation and Arbitration and Mediation Center, Hyderabad, IIMC. Kindly visit their website. They have model clauses that are made available as part of the website. They would come in handy, and to the extent possible, incorporate them. I know personally, because I have used their services, that they are extremely reliable and very cost effective. So if a matter is amenable to be mediated in India, I would suggest IIMC as one of the options. And of course, there are a lot of other options which we don't have time to get into now. But there are competent institutions in India that can handle these matters, including very complex commercial matters in our country.
Thank you, sir. One more question. Given the recent Supreme Court judgment on unenforceability of arbitration clause in an unstamped agreement, is it a good idea to now have the dispute resolution mechanism as a separate agreement altogether?
So that is a very valid question. I think to the extent that it can be achieved without a lot of additional burden, my recommendation has always been to have a separate arbitration agreement. Because in a single clause in a large context of a large contract, it may not be feasible for the parties to adequately represent their full intent when it comes to alternative dispute resolution. At best, they can copy paste a very cookie cutter, standard, off the shelf kind of a clause without much thought going into it. Now that we have the mediation bill almost ready, hopefully it will become law, and we have the Arbitration and Conciliation Act of '96, we have 3 codified statutory options before us. If we can develop a standard agreement of some sort for each company that talks only about ADR, so it could be titled an ADR agreement, and a reference could be made to it within the main agreement, be it a concession agreement, be it an employment agreement, whatever it could be, that any disputes arising out of or in relation to this particular agreement will be governed by a separate ADR agreement to be entered into the parties, either simultaneously or pre or post, that doesn't matter. That would be my recommendation, especially in light of, like your member has rightly pointed out, in light of the recent judgment. If that is not possible, obviously try and make the ADR clauses in your contracts less cookie cutter and more suited and personalized to each of the agreements. That is my suggestion, with obviously the right duties being paid on these agreements, which always has been a good idea anyway. Yeah.
I'm going to the next question, sir. When is mediation not suitable for resolving certain types of disputes? What alternative dispute resolution methods can complement or replace the mediation in such cases?
Now, we actually have a Supreme Court case called Afcon's Infrastructure versus Cherian Varke Construction. I will give the reference here so your members can look it up after the session. It's 2010 8 SCC 24. 2010 8 SCC 24. So in this particular judgment, the Honorable Supreme Court not only settled the so-called issues that can be settled through the ADR process, but they have also identified those disputes which cannot be settled through ADR process. For example, they said the suits that are mentioned under, for example, Order 1, Rule 8 of CPC, which are basically those that involve public interest. Those are the types of disputes that cannot be settled through ADR process. The Honorable Apex Court said the election disputes, for example, when we are talking about election to public offices, which is a very important part of our democracy, a pillar of our constitution, those kinds of disputes cannot be settled through ADR processes. If there are disputes that are related to serious allegations of fraud, money laundering, for example, if there are allegations of document fabrication, this is one of the questions that one of your members had raised with the respective documents. And I said, the veracity of the documents has to be decided as amongst the parties, inter se the parties. But if there are allegations of fabrications of the documents itself, or forgery, or impersonation, for example, or if there are allegations of coercion by one party to the other, then clearly ADR cannot be applicable according to the Apex Code. They also identified certain special cases where they said, if you want the protection from courts, if there are claims against minors, right, if there are issues relating to religion like deities, if we have mentally challenged people in the mix, or if there are declaration suits where a government is a party, for example. And clearly, like I said earlier, any criminal offenses prosecution. These are all the things that the Honorable Supreme Court has already settled, saying these are the things you cannot settle through mediation or any other ADR process.
Thank you, sir. Next question by one of the participants. What he is trying to convey is India is a signatory to the Singapore Convention, but India is yet to ratify that. What does it mean? Is being signatory not sufficient? Further, what will be the changed scenario once it is ratified by India?
Right. So basically what happens is, the steps that we follow in a treaty generally is the first the text of the treaty is introduced to the world. Then different jurisdictions and countries are invited to be signatories. There is an entire process that is set out by the United Nations. I think we don't have time to cover that in great detail here, but very on a high level, the 3 steps are the introduction, being a signatory, and ratification. So once the introduction is done, those countries that are interested in that particular treaty can send an authorized representative to sign that particular document, saying that we are now signatories to this particular treaty. But the actual effective implementation of that particular treaty will only happen after the said treaty is ratified. And typically every state, by state I mean a country or a jurisdiction, every state has its own rules and principles as far as how a treaty can be ratified. Sometimes it's an executive function, sometimes it's a legislative function. In our country, it is a legislative function where that particular thing has to be ratified by our parliament before we then send a representative to the United Nations to actually give what is known as an instrument of ratification, which then finalizes the final step of the process. But we are not there yet, and neither are majority of the 56 countries that have signed on to this particular treaty now, or the Singapore Convention. Majority of them have not ratified it. Once it is ratified by all the countries, then if any new country wants to get themselves under the umbrella of the treaty, then there is a process known as accession that happens, where that new country accedes directly to that particular treaty. So these are all very complex issues that I don't think we can cover in the next 5 or 10 minutes that we have left. But yes, we are at stage 2. We are yet to go to stage 3. And the process of introducing the mediation bill is towards that process.
Sir, the next question from my side, in the context of cross-border transactions and international business disputes, how can mediation adapt to diverse legal systems and cultural differences to achieve equitable outcomes?
Sir, that's a great question. I mean, effectively, what you're asking is, when we are talking about international mediation, how do we account for the cultural differences? I would say the main goal of mediation itself is effective communication between the parties. And in my view, in whatever international work that I have done, when there is an intent by the parties to settle amicably, they are more than willing to understand the cultural nuances and to bring those cultural nuances to the table, to accept them, acknowledge them, and to work around them. Cultural differences per se, in my view, so far, in my experience, has not been an impediment or an obstacle for parties to reach any sort of a solution. Having said that, not accounting for the cultural differences, in my experience, has resulted in mediation failing. There are certain terms, there are certain actions, there are certain practices, I would call it, that are very common to a certain culture that may be uncommon in another culture or may even be offensive in another culture. The way we nod our head to indicate acceptance is different from country to country. And nodding a head in a particular way, which may deem to be acceptance in a certain country, may be entirely offensive in another country. So cultural differences to that extent are important for us to understand, recognize, and then adapt. But based on, in my experience, as long as there is a willingness of the parties to come together, I have seen that they have overcome this over time.
Sir, one more question being asked by one of the participants. His question is, once a mediation bill becomes act, whether Section 12A of Commercial Court mediation also becomes optional, as today it is mandatory as per court?
Sir, I think we've talked about this in sections 58, clauses 58 through 65 that I have put up earlier on the presentation. And I believe that the idea here is that all of the unique legislations that have the mediation clauses now will be subsumed by the consequential amendments from clauses 58 to 65. And that includes the Contract Act, Arbitration Conciliation Act. We know definitely that the Arbitration Conciliation Act, conciliation is being subsumed by mediation. And we also know that CPC, Commercial Courts Act, Legal Services Authorities Act, Consumer Protection Act, Companies Act, and MSME Act are also being consequentially amended. Whether it is being completely replaced or not, we'll have to wait for the final text of the bill. But kindly refer to clauses 58 to 65 to the participant who asked the question. Kindly refer to clauses 58 to 65 of the mediation bill as it stands in its current avatar, with the disclaimer that this will change once the implementations of the JPC amendments as well as the cabinet approval is implemented into the bill.
So next question, sir. What role can company secretaries and corporate counsel play in promoting the use of mediation within their organizations and fostering a culture of dispute resolution through non-adversarial means?
Sir, I think this is a change in mindset that is required. The urge to approach the court system at every opportunity, first of all, must be taken away. I mean, that is where the entire thing starts. And this is contra to my own profession and development and growth, but I'm still saying it. We need not go to court every time there is a dispute. Companies must first come out of that mindset. The second mindset change that needs to happen is, okay, if there is a dispute and court is not the be-all and end-all forum for resolving such a dispute, then what else is there available for me to do so? So once the recognition happens that the court is not be-all and end-all, then the opening up of the eye automatically happens, seeking for alternative mechanisms. That is where mediation and arbitration comes into play. Now, what you can do as company secretaries, as advisors to the CEOs, CFOs, and the chief legal officers is to take small steps towards mediation. One of the clients that I have worked with in the past, a large institutional client, what they had done is they said, any dispute below a certain quantum, we will go ahead and implement mediation as a mandatory first step. This is not an MSM, it's a rather large organization. They put a quantum. Now that quantum can be different for each company that your members are associated with. It could be 25 lakhs, 50 lakhs, 1 crore, or for a very large organization, even as high as 5 crores or 10 crores is possible, where you can say that as long as the quantum of the dispute falls under this particular threshold, mandatory mediation must be instituted. Once you come up with that policy, then that should be integrated obviously with each and every one of your contracts that you will be entering into with third parties outside your company. And it should be made a standard policy or maybe a standalone ADR agreement that I have suggested earlier. That is a start. Once the flavor of mediation is tasted by the powers to be, once they understand the time and cost effectiveness of the process and what they can achieve in a very limited amount of time with the finality of a result, and hopefully once the mediation bill becomes a law, the result having the force of law as a decree of a civil court, then that quantum can be increased over time and more disputes can be brought under the umbrella of alternative dispute resolution. So that is one practical tip that I can give you. We cannot change the system overnight. We cannot change the way our officers are attuned to going to courts for every dispute overnight. We cannot change it. But what we can do is a very practical solution which says, and if in your company, it means that quantum or the threshold is only 1 lakh, let it be. Start somewhere. And then you can start building on it in the future.
Thank you, sir. Next question, interesting one. The question raised by one of the participants. Eligibility says 15 years of experience in practice for all the professionals, ACS, ACA, and ACMS. But what about persons working in industry and now retired?
So 15 years of experience, we were talking in terms of the Companies Act, right? I mean, is that the question, sir?
No, what they're trying to say, if he's not a practicing professional, but has only worked in the industry and are now retired, or whether they can become the mediators. That is the question.
Sir, that is to be seen based on the. Let me look at the regulation, because I think I've given a copy of the regulation in the presentation. Yeah. That is to be seen. If you look at the last but 2 slide, you also have the final. Are you projecting the slide, sir? I cannot see on the screen. But anyway, right. the final point of the slide, I will read out for the benefit of your audience.
Yeah.
It says, so one of it which I have covered says it's been a professional for at least 15 years as a company secretary. But then there is a catch-all provision there. It says is an expert in mediation or conciliation who has successfully undergone training in mediation or conciliation. So even if you have not been a practicing company secretary necessarily for 15 years, as long as you have undergone training in mediation conciliation, which means that on some levels you have achieved or attained the expert status due to your training, you can still apply to be a mediator with the central government.
Thank you, sir. We have no more questions to ask.
Thank you, sir.
Can I conclude, please?
Yes.
Yeah. On behalf of the ICSI and those who are participated in today's webinar, I wish to just inform you that roughly around 11,000 participants have watched your presentation, and I commend your knowledge on the subject, giving an overview on mediation and conciliation, and of course, what is the difference between mediation and conciliation, as such the statutory framework under which these provisions are covered in the bill, and other issues, personally, what you felt should be looked into from your point of view, and also highlighting the role that can be played by the company secretaries in the days to come in the specific area. Sir, I extend my heartfelt gratitude to the Institute of Company Secretaries of India for organizing this webinar and providing this platform for us to come together and learn. It is through this initiative of ICSI, we collectively enrich our knowledge and build a stronger foundation for skill advancement in the area of mediation and conciliation. I am sure that the valuable insights and the experiences shared by Mr. Gandhi on the subject will certainly be helpful in enhancing our understanding on the dispute resolution mechanism. Sir, my special thanks to you for sparing your valuable time and sharing your valuable knowledge on the subject. I also thank all the participants for their active participation during the webinar. Thank you very much, sir. Thank you very much.
Thank you. Thank you, sir.